Hi, everybody. Thanks, Ashley, for setting this up. Again, my name is Jay. I am a volunteer educator with the Financial Education Partnership, otherwise known as FEP. We are a 501c3 nonprofit based out of the DC metro area. I also own Go Comprehensive, which is a retirement guidance firm right here in Harrisburg. I have lived in the area since 2004, been in the industry since 2008, and started my firm back in 2016. And it's been a real pleasure, to help out our neighborhood and get these programs out there. So FEP was started, and actually I'm going to turn off my video because I can't stare at myself talking. So if you don't mind. All right. So FEP was started by a gentleman by the name of Jonathan Lee. He was a prolific financial advisor back in the mid 2000s. He was #1 for MetLife when they were at their pinnacle. He was #1 for Athene. He was a high level advisor with American Funds. So needless to say, he had a tremendous amount of experience. And in his work, he realized that the financial services industry is really good at selling products, mutual funds and life insurance and programs like that, annuities and those kind of things, but they're not really good at helping you actually make an actual plan with all those products. So he stepped back, and in 2008, he started FEP with the premise of reaching out to people like me, to estate planners, to lawyers, to CPAs, to insurance companies, and say, look, let's all join this organization, build some programs, and you go out to your neighborhood and share this knowledge, no strings attached. So that's what we've been doing. And I'll tell you, from my point of view, after working with this group and having a good mentoring program in place, I have dramatically changed, how I see my retirement and what I'm going to be doing for my family as things go on. And not only has this influenced myself, but my parents and also all of my clients. I have many clients right here in Dauphin County that have benefited dramatically from these services. And again, this is a nonprofit. We're not here to sell you anything or offer anything. We're just here to give you some guidance. And then if there's a way that we can help you, we'll talk to you about that. So I would urge everyone to make sure you have a pen and paper handy. There is a lot of information that we're going to go through. And leaving your legacy, especially after this last year, is quite an important topic. There was, 500,000 people lost in this country alone, and a lot of them passed away unexpectedly. And when you don't have an estate plan in place, it's very costly. It not only is an emotionally very, very difficult time to have to go through, but then to have to pick up that person's estate and figure where it's all supposed to go is a really, really difficult thing to have to go through. So definitely get a pen and paper, get it going on it, and take some notes. And then I'll have a question and answer opportunity at the end of the presentation here. And I would urge you, if you do want to talk about this stuff for yourself personally, if you don't feel like asking these questions in the group format, reach out. Don't wait till next week. You can email me tonight, email me tomorrow. Don't wait till Friday. Just email me and we'll gladly set up a time and we'll chat about your situation and see what I can do to help you out. So let's get into it. So what is your estate plan, right? What is your exit plan is what we also call it. So first up, what's an estate? An estate is all of your stuff. That is your house, your car, your retirement accounts, your IRAs, your savings account, your widgets, your Chia Pet collection, your anything you can imagine. That's what your estate is, okay? And what an estate plan is how do you efficiently and effectively pass on your stuff to your beneficiaries with the least amount of cost and burden, okay? Now, when we're thinking about estate planning, we're really running into 3 types of groups. The first group, is a parent set that, love their kids and want to give their kids every single penny that they possibly can. Then we got the next set who are also parents, but don't really like their kids. I'm just kidding. But maybe their kids have done very well for themselves. Maybe the kids are doctors, maybe their kids are billionaires and they don't need anything from mom and dad. And then the last one would be the hybrid, where they're trying to live off of their money, but also try to pass on as best as they can. And going back over those 3, it's difficult. When you think about that first group, if they don't plan for things like taxation, for the beneficiaries, if they don't plan for things like long-term care, it is quite difficult to pass on as much of your estate as you want to. The second one, who doesn't really care about what their kids get, we don't know when we're going to die. So we don't know when we can cut that last check. And if we don't set up in a plan for the remainder of our assets that we didn't get to spend, it can be very costly. And lastly, this is the group that has the hardest time, is the people that are trying to do both, to live and give. And for those situations, there's a lot of things that drag on your estate. There's fees, there's market fluctuations, there's inflation, there's long-term care. And, without making a proper plan to combat all those things, it can be difficult to pass on an estate well. So what happens if I die without a will? So if you pass away without a will, what it's called intestate. So basically, if Mr. Smith passes away, the courts get record and they say he has no will in place. So they'll go and assess your estate, and then they will try to find the next of kin, and they'll use a generic will to pass on those assets. This is not something you want to have happen because of a couple of things. First off, it's up to the courts to decide where everything's going to go. Next problem, though, is the cost. It's very expensive because you're paying for all those legal services to find the next of kin. Next of kin lives in another country. It's a nightmare. So you definitely want to have at least a will in place. So let's talk about the 3 parts to a will for your planning purposes. So there's 3 parts. First part is the last will and testament. It's exactly what it sounds like. Upon my death, I want these things to occur. I want this money to go there. I want my funeral plan to be this. I want my ashes spread here. That is what a last will and testament does, okay? Number 2, a living will and medical directives. A living will is basically if you are incapacitated, but still alive. So if you get intubated or brain death or something terrible of that nature, this basically says what you want to happen with your body. This is important. You guys may remember this case where there's a lady by the name of Terry Schiavo. I believe she lives down in Florida. It's about 5 or 6 years ago. And this poor lady had an accident and she had brain death but was still alive. And her husband wanted to take her off of life support. And her parents said, no, Terry would not have wanted to die and I want her to live. So they countersued and they sued back and forth each other for over a year. This poor girl was taken off life support a couple of times, put back on life support a couple of times. And it was a real emotional, financial mess. So having a living will with medical directives is a really, really, really important part of the equation. Now, a general durable power of attorney is kind of like a living will for your money. So if something happens to you where you're incapacitated and you need to make sure the bills are being paid while you are not able to answer any questions, that is what that is for. So again, a very important part of the equation. And if you don't have a will in place, there are wonderful services like LegalZoom, Rocket Lawyer that can help you build a will pretty quickly and for not too much money. So definitely keep that in mind. Now, it is important to understand that a will does not avoid probate. So what is probate? Probate is when you pass, your will goes to probate court and it's proven at that point in time. So Mr. Smith passes away, the will goes to probate court and it says, okay, Mr. Smith, this is a valid will and Mr. Smith wanted these things to go to these beneficiaries, okay? Now, a couple of things to keep in mind with probate. First off, it takes time. It takes anywhere from 6 months to 2 years, depending on the complexity of the estate. It also is an opportunity to be contested. So someone could come and say, Mr. Smith said he was going to pay me $10,000 for the work I did to his house. I just never got to it. And that can hold up the probate situation. There's also the cost. It can cost anywhere from 10 to 15% to have your estate go through probate. So we're going to talk about some ways to get around probate. There's not for every situation can you get past probate, but it is important to understand that there's a cost and the time for the probate service, okay? All right. So let's go on to, this is the next section we're going to talk about is things you can do to avoid probate, all right? So really what we're talking about is beneficiaries. So on the right, you'll see TOD and POD. So POD is payment on death. So that is basically making it a beneficiary for your bank accounts. So if you have a CD, you have a money market account, you have a checking account, you do a POD. And it says, okay, upon my death, this account gets passed on to my beneficiary, okay? A TOD is a transfer on death. So this could be a thing like in this, like a home. or this could be stocks or bonds or I think mutual funds, but I'm not 100% sure about that. But yeah, stocks or bonds. All right. So basically, upon my death, I want them transferred, not sold. I want them transferred to my beneficiary. We'll talk about how that's a pro in some instances in the future here. Now, if you look to the left, you'll see a beneficiary deed and a life estate. So beneficiary deed and TOD fall in the same realm. So what you do with the beneficiary deed is you change your deed, you redo your deed, and you make a beneficiary deed. And it basically says that upon my death, I want to go in directly to this person. So that is a good way to avoid probate. It does not avoid all inheritance taxes, and there is a potential capital gains issue to have to worry about, but it does help to avoid probate. Life estates, same concept, but instead of a beneficiary deed, you're going to set up a trust. And within that trust, you say, okay, I want this house to go to this person. Now you're taking the ownership of the house away from you and putting into the value into the trust. It's good and bad. It's good in the fact that it helps to protect the house against Medicaid and those kind of things, but it could be difficult for the beneficiary because it could classify as a second home. So when they go to sell the house, they could have a capital gain situation to be aware of. So pros and cons, but all helpful if you're trying to avoid probate. Okay. Can we hear me okay? We got some backup. Okay. All right. So gifting is the next thing a lot of people like to do. So as a parent, I can gift to each of my children up to $15,000 per year, and they do not incur any type of income tax for that purpose. All right. Now, if it's a couple, that means you can give $15,000 to each kid twice. So you can give $30,000 to each kid, which is a tremendous amount of money, which would be fantastic for them. But the problem is, if you do not plan for things like long-term care, and if God forbid one of you come down with dementia or Alzheimer's and you have to go into a home, Medicaid, who would typically pay for your medical expenses for nursing home care, will look back 5 years and they'll say, well, you've been gifting you this money to your children. We want that money before we're going to take care of you. And if you don't have the money, we're just not going to offer any benefits for a couple of years. So they get you one way or the other. So it's important to understand that gifting is a great way of doing it, but you have to realize that if you don't structure it properly, it will hurt you in the future if you do have long-term care needs. And the last thing we're talking about is, second last thing is co-ownership. So a lot of times people say, instead of doing a beneficiary deed or a trust, I'm just going to make my kids the co-owner of my house, of my car, of my bank accounts, which has its benefits. But the one thing you got to keep in mind, if the person that co-owns your account gets sued, those assets you have co-ownership of are also open to being sued. All right. So, and I know a lot of us say, well, my kid will never get sued, but your child could have, or I should say, like your grandkids could have someone over to their house and they could fall and they can get hurt on a freak accident. You can get sued for that. And if your co-ownership of your parents' policies or your parents' property, that all comes open to the lawsuit. So it's real important to understand that you open a door for yourself to potential legal issues by having co-ownership in place. Not a bad thing, but you need to be aware of that fact, okay? Now, the last item is a life insurance policy. So life insurance is still the last real vehicle that passes truly tax-free to your beneficiaries. It's really the only vehicle that we have right now, especially after what's happened last year, that truly skips all of it. Skips probate, skips income tax, skips everything. Now, there is instances where a life insurance policy could be taxed under estate provisions, and we'll talk about that in a little bit here. All right, so let's keep on moving forward. We're doing my time. All right, good. So to trust or not to trust. So what a trust is basically taking assets out of your name and putting it into this vehicle. And within this vehicle, the benefit is you avoid probate by putting stuff into a trust. You're also removing values from your estate. So for tax purposes and those kind of things, it can help out. But there are some pros and cons to it. So first off, within the trust, if it's not structured properly, there could be a very high tax rate to have to pay. So if you don't plan for it accordingly and it starts distributing income to your beneficiaries, that income could be taxed up to 50%. When that happened recently to a client of mine, his dad worked hard and he set up a $10 million trust, which is an incredible amount of money. And it's distributing money to all four of the siblings. But because of the way they structured the trust, there is a very high tax rate. So it's getting taxed at over 50%. So instead of passing on $5 million, or sorry, $10 million, they're only passing on 5. And that seems like a real loss, to say the least. So without proper planning, it can be a very cumbersome situation to work within. So there's 2 types of trusts available. There's revocable and irrevocable. So revocable trusts, you can make changes to the trust in the future. So if you have beneficiary changes, if you want to redo the entire thing, you have that opportunity. An irrevocable trust is ironclad. And what I mean by that is if you set up an irrevocable trust and you say, okay, I'm going to tie all my assets into this trust to avoid probate and try to avoid income taxation for the kids, okay? But now say there's a falling out with one of your beneficiaries and you don't want that beneficiary in that trust any longer. If you want to change that trust, that beneficiary has to agree to the change. You can't just say, I'm going to take them off. I want them off the situation. They have to agree. And that's where things can get dicey. So it's important to understand the benefits between them, but really more important to understand how they structure over time. Special needs trust is for a parent of a child that has special needs. When a child has special needs in this country, they qualify for Medicaid much easier. So if they have autism, Down syndrome, so they'll have medical expenses pretty well covered for by the state and federal government. Now, if a parent passes and they pass on a sizable estate to their children who has special needs, the child could lose their medical benefits and have to worry about paying for all that out of their own pocket. And if they don't have an oversight to say where the money is supposed to be going, it could be a real mess for that child. So a special needs trust, which we do have a lot of experience with, is a very valuable thing that really can help out with structuring assets to be passed on to that child in a way that doesn't affect their medical benefits. Life insurance trust. So before we talk about life insurance, and 9 times out of 10, it passes to the beneficiaries free and clear of taxes. But if you have a sizable estate and you have an estate, say, worth over $10 million, and you have a life insurance policy within that trust, within that estate, that can get taxed under estate tax. So by setting up a life insurance trust, you remove the value of the life insurance policy from your estate, and that way you can go to the beneficiaries with a much lower tax implication. They call it an ILET, is what the abbreviation of it is. Fantastic vehicle. Again, if you have a large estate, something to really think about. And let us know if you have any questions. We'll be happy to help you out. A family trust is just what it sounds like. It is moving assets between bloodline. So if I only wanted to go to my kids, not their spouses, that's what a family trust is for. And if I wanted to go to my grandkids and not their spouses, again, that's what the family trust is for. All right, let's keep on moving here. No one fell asleep yet? Good, so we're doing okay. All right, so owning assets, super important. Seems like not that complicated, but it's very, very important. So say you are a single, graduate from college, buy a car, buy a house, have a 401k, everything's in your name. You get married 5 years later, have a kid, okay? You have to make sure you set up your beneficiaries. You have to make sure you set up joint ownership. Car is one of those big ones. This consistently happens every year. Retiree, he only drives the car 5,000 miles a year, brings it in for a service at the dealership sees the car, they see the low mileage, they say, Mr. Smith, we love your car. We want to buy it off you. We're going to give you 130% of the value. Let's get you set up with this lease over here. And he goes for it. He says, well, I only drive so much. I'll save a little bit of money. I'll go do this. So he gets behind the car at a lease. His wife is not there. So the car is in his name only. Now, fast forward a year, he passes away unexpectedly. Now, for that wife to get that car put back in his name, in her name, it's a major mess. And in some instances, they will make you pay the sales tax on that car again to transfer that asset back into her name. So, and the same thing goes for utilities. The home's a big one. Like, you do not want to leave yourself in a position where you are married and only one person's on the deed. It's not ideal, to say the least. So definitely get your joint ownerships set up when you need to, okay? Now, joint ownership with the right of survivorship, that is going back to the family trust, family bloodline kind of concept. So say I own property. Say I own property in Dakota, South Dakota, and I have 2 kids, and I set up joint ownership with right of survivorship. So me and my wife own it. We pass away. It goes to our 2 children. Now, if one of my children pass away, if you don't have it set up this way, it goes to their spouse, right? But if I say joint ownership with right of survivorship, it ends up going to my other child. So when one child passes, it goes to the other child, and then it goes from her to whoever she designates at that point in time. So that's what right of survivorship is. Again, following bloodlines, if you need to worry about that for the future. All right, guardianship. So this is really kind of important if you have minor children, so children under the age of 18. If you have children and you don't have a guardianship set up, if you were to pass away, 2 things happen. The courts decide where the children's going to go. That's the first big concern. And the big driving force behind that is also the assets of the family are also under the guardianship as well. So we've had instances where, we have a family and they have an aunt that lives in town that has 2 children of their own. They all go to the same school district. The cousins are like peas in a pod. They are happy together, and the parents pass away unexpectedly. And in normal circumstances, you would say, well, we want the aunts to take the child, but you never set up guardianship. So the courts look at it. The courts say, well, there's an uncle that lives 2 states over, and he has a good job, and he has a nice house, and he has the financial ability to take care of these children. The aunt that the kids know and they feel comfortable with lives in a 2-bedroom apartment, doesn't have a great job, has some credit card debt. The court might very well say, we're going to send the kids 2 states over. And that's why setting up guardianship is such a big deal. And these are all in that light. Grandparent guardian, if your grandparents are ill, you set up a guardianship to protect their best interests. That's also what a power of attorney is for. Personal guardians, children of special needs, property guardians, if you have a piece of property and you don't want it sold, but you do want to maintain, that's what the guardianship would be for. All fantastic vehicles to make sure that what you want to happen does occur. Not hard to do. Don't stress yourself out. Just get it done. You got LegalZoom, you got Rocket Lawyer. These are services out there to help you get these things set up to make sure your children, your family, and your assets are where they want to be. Okay, so we're cruising along pretty good here. All right, so this is where we get kind of into the meat and potatoes of the conversation, death and estate taxes, because these have the biggest effect on your estate if you're trying to pass it on, okay? So first we're talking about federal estate tax. So in 2016, the federal estate exemption was changed from $5 million for an individual to $10 million, and for a couple from $10 million to $22 million, okay? That exemption is going to end in 2025. Now, will it stay? I don't know. This changes all the time because it is a big way for the government to make up cash revenue issues. And especially with all the COVID relief plans that have been passed over this past year, I do anticipate this to go back down to where it was for the future. So what it means and how it works is they look at your entire estate, and that means everything. That means your life insurance. That means your IRAs. That means your 401ks, your 403bs, your TSPs, property, cars, everything. And they look at it and they say, okay, well, if this person's value is above $5 million, and this is now I'm saying this is assuming this is 2027, they went back down, say it's over $5 million, anything above that $5 million will get taxed. And the tax rate is anywhere from 35 to 55%. A huge taxable burden. And I know a lot of people say, well, that'll never happen to me. Just 2 weeks ago, I have a client, they grew up extremely poor. There was plenty of nights they went home, they went to bed hungry. Her brother never married, worked hard, saved his money. He died. He just gave her $2 million. Never expected, she was never planning on it, but boom, she just had a massive change in her estate value. And if that money grows over the next 25 years, it could be $5 million before you know it. And if you don't plan for that tax burden on the estate side, it can really eat up a big chunk of it. So let's just go back to that example. Say you have $10 million and it's just you now, okay? And you have a $5 million exemption, so $5 million cannot be taxed. But the other $5 million can get taxed anywhere from 35 to 55%. So say the tax is at 40%. That means $2 million of that estate is going to tax purposes. So really important, and especially understand that life insurance falls within that purview, and that's where it can become taxable. So it is important to say that if you have a decent estate, you really should be planning for it, okay? Now, the other tax that can really affect your estate is federal income tax. Now, this is the one that most people will be affected by. On the left side, when you're talking about estate taxes, most people don't have that kind of assets, but you never know. But for most people, the right side is where you're going to get hit. And what I mean by that is if you have a retirement account, if you have a 401k, a 403b, a TSP, and you are contributing to that investment account or that retirement account every paycheck, you're taking money out of your paycheck, pre-tax, the company you work for might match that, and that account grows. And it grows and it grows and it grows and it grows tax deferred. So when the time comes that you take money out of that account, it's 100% taxable. So you have to pay income tax on distributions when you take money out of that retirement account. Same deal for your heirs. So I'll give you a great example. Say you have $1 million in retirement accounts. I know, again, $1 million sounds like a crazy amount of money, but two people making $65,000 a year doing that for 30 years, you can easily have $1 million in a retirement account, okay? So you have two children, and those two children, you would hope that they would get 50% each, right? They get 500,000, 500,000. But wait, there's an important difference here. You have a third beneficiary. So they're not going to get the $500,000. What's going to happen first is going to be the third beneficiary, which is the federal government. So if you look at a tax table, and this is the tax table for 2021, and if your children, say, make $100,000 a year, they're right now in the 22% tax bracket. Now, if they inherit a $500,000 apiece, they go all the way down to here, and now they're in the 35% tax bracket. See how that affects you? Okay. So now, instead of taking home the $500,000, what happens is federal government takes that 35%. So they take $350,000 out of that retirement account, and the kids get $325,000 apiece. So $175,000 loss per child for taxes. Okay. And remember, these tax brackets that are in place right now are based on the new law that's also supposed to end in 2025. And again, with all these relief bills that have been paid and the $3 or $4 trillion that have been given, I do anticipate these things to change. So it's important to realize what kind of burden we're going to be dealing with for the future. Okay. So that's the first issue that people have to worry about when it comes into federal income tax. Now, there's some new changes that are also very important to understand. So there's a thing called the Secure Act that was passed at the beginning of this year. I'm sorry, beginning of 2020. It was passed with bipartisan support, and it's really made some big changes to retirement accounts for the future. So first off, there's an RMD rule. So the RMD is basically a required minimum distribution. So if you retire and you have a retirement account, you have to take out so much money out of that retirement account every year so that they can tax you on that distribution. So now it used to be that you have to take that distribution at 70 and a half years old. Now it's 72. So you can defer, and take out the money out of that retirement account at 72. Problem is, say you had that $1 million. Say you don't touch that $1 million. Say that $1 million grows to $1.5 million in 7 years. Now you got to take out 4% out of that account at 72, which is $60,000. And going back to that tax bracket, say you're married. Say you're right now in the 12% tax bracket. You're only making $65,000, $70,000 a year, but you're comfortable. Now you got to start taking out another $60,000 out of that retirement account. What happens? You jump 10% in your taxable income. Okay, that's a big jump. So is it the best idea to defer, or is it smarter to take those RMDs now and start converting that money sooner to Roth IRAs or life insurance? That's a question you have to ask for yourself. But in my book, that's what I'm going to be working on, because I would rather see me paying a lot less in income tax, or more importantly, my spouse and my kids paying a lot less in income tax if I'm not around, versus not doing anything and having them pay 35 or 37% or whatever it may be, because of a taxable burden. So that's the first hit. The second hit, which was a huge surprise for us, non-spousal inherited IRAs. So it used to be that if I inherited an IRA from my dad, I could spend that down over my lifetime. I would not have to spend it down in a certain period of time. I could take out 3 or 4 or 5% per year and not really push myself into a different tax bracket. Okay. Now, if you inherit an IRA, you have 10 years to spend that IRA down. Okay, I'm going to say that again. You got 10 years. So now if I get that $1 million IRA, I'm going to have to take out $100,000 a year, which is absolutely going to push me into a different tax bracket, and cause a financial burden to me for doing so. If I do not take that money on the 10 years, there's a 50% penalty. So say you leave that money in there, that $1 million, you say, I don't want to touch, I don't want to do anything with it. Grows to $2 million, and you wait the 10 year. On the 11th year, you said, oh, I should take some money out. When you do, they'll take a half of whatever you take out as a penalty. Okay, it's a huge problem. It's a real surprise. It's accelerated a massive amount of taxable income for the government. I'm not saying that I don't want to pay my fair share in taxes. I'm not saying that at all. We all got a taxable benefit for having a 401k. I'm just frustrated with the fact that we were never really told how to plan for this. It's a very difficult thing as far as estate planning is concerned. It's a very difficult thing as far as income planning is concerned. So I would much rather do whatever I can when I can and try to reduce that taxable burden to my family. And I'm okay with paying 10 to 15%. I'm just not okay with paying 35 to 40% in taxes. So let's talk about what we can do to kind of circumvent some of those tax burdens. All right. So these are some strategies that you can use. Now, it's important to understand this is not a one-size-fits-all kind of situation. Everybody's situation is different. If you want to have a conversation, reach out. I'll be more than happy to have a conversation with you about what I think you can do for your benefit. Again, there is no cost to this. We are a nonprofit. It's really just more about education and getting you guys in the right direction. So first off, maximizing spousal exemptions. So it's important to realize when you are married, you have a much bigger window of income that you're allowed to earn and still stay within that 12% tax bracket. Same thing here, 172 as a couple, and you still stay within the 22. Okay, you also have a bigger standard deduction. So those are all great tools to utilize to help convert some of your money to non-taxable money for the future. Okay, it's also really important to understand that when one spouse passes, the widower gets to keep that tax bracket for 2 years. So they get to keep this middle column for 2 years, okay? But after that second year, they go down to the individual bracket, okay? So now if you still have that IRA that you're taking all that money out of, and you also have your Social Security benefits, maybe you have a pension and some other things going on, your tax bracket is going to jump dramatically, maybe even as high as 24% versus the 12 that you were at before. So it's real important that if you can, maximize those deductions that you have while you're together and alive and convert some of that money. Make it work for you in a more efficient way so that you're not burdened with the high tax costs in the future. Marital trust. Marital trust is used to help with the estate exemption. So right now, a married couple has a $23 million exemption. We do anticipate that to go back down to 10 million come 2025, but say it doesn't, say it stays, okay, and someone has $25 million in the estate value. A marital trust can help to double that estate exemption. So you can have $44 million and avoid an estate tax issue at that point in time. So very helpful, very useful, not very common, but you never know. So if you have it, keep that back in mind. Bypass trusts. Bypass trusts are exactly what they sound like. They skip a generation. So instead of your money going to your children, it goes to your grandchildren. And you can set it up in a number of different ways to help offset college expenses, maybe help them purchase the first home, whatever it may be. But again, if it's going to distribute income, you've got to be very, very careful about what their tax rate is going to be and if it's going to cause issues for them income-wise in the future, okay? Capital gains. So before we talked about TOD, transfer on death. So what that is, that really relates to stocks. So if you have a stock, and we'll go over what a capital gain is. So if I have a stock and I buy a stock for $100, that's my cost basis. And say that stock appreciates to $1,000, okay? That difference between the value of what it is today and my cost basis, otherwise known as $900, that's my capital gain. So if I sell that stock today, I will have a capital gain of $900 that I will have to pay taxes on. Now, when your children inherit your stocks, if they do a TOD, they get the brand new value as their step-up basis. So they get it not at 100 for their basis, but at 1,000. So that means that they can technically sell all their stock and not pay a capital gain on it. There's going to be other taxes they have to deal with, but it is a really important benefit of owning stock, is that you can pass it on and they don't have to have all that appreciable growth and pay taxes on that benefit. Now, there is talk that this is up in the air for tax law changes. If it does change, it's going to be a little more difficult. But I still think it's something that's really valuable for the future. Insurance trust, we talked about that before, and the value of an insurance trust to help avoid estate taxation. Very valuable system. You have any questions about it, let me know. Income tax is a part of life. You know, we're going to deal with it one way or the other. We can't avoid all taxation, but we can definitely reduce the burden of it all over time. Now, if you say, I don't care, my kids are going to get all this free money from me and they're going to pay the income tax, so be it. And so be it. That's your life. You're allowed to absolutely do that. But if you're not, and you want to talk about ways to reduce that burden, let me know. I'll be happy to help you out. So the last thing we're going to talk about is called a CRUT. It's a wonderful acronym, but it stands for Charitable Remainder Uni Trust. Charitable Remainder Unit Trust. And it's a fantastic tax loophole to help out with income taxes for the future. So, and this is something that has been around for a long time, but most people don't know anything about it. And if you look up Charitable Remainder Trust and type in like any university you can think of, Charitable Remainder Unit Trust, Penn State, it'll show up right on Penn State's website. If you type in the same thing for Harvard, Carnegie Mellon, Pitt, every university in the country has this referenced in their giving programs. And it's a really neat program. And what it basically means is that if you have assets that you would like to donate, most people would love to do that, but they can't do that now because they need the money to live off, right? They don't want to give it all away, so they need the cash now, right? And then a lot of people don't also commit to passing that money on when they pass away because they don't reap any kind of taxable benefit for themselves. So what a trust does, a charitable trust does, it allows you to give them money today, designate your beneficiary, they will get that money in the future. This trust will also pay you an income. So it gives you money to live off of. And then on top of all that, it gives you the tax deduction today, not 30 years from now. And the tax deduction can be a big deduction. So, you know, you could say you want to put $100,000 of money into this trust, and you would reap a $50,000 tax deduction. So if you have a $500,000 IRA that you would like to convert to a Roth, that's a fantastic way of doing it. And this has been around forever, just no one ever talks about it. It's not terribly complicated. You just have to have a decent CPA and a decent lawyer to write up the draft of the documents, and you're on your way. It is revocable, so you're not locked into anything. You can change your beneficiaries in the future. You can change your charities in the future, but it's a fantastic vehicle to use to offset taxable burden for yourself so that you can turn more of that money into tax-free money for the future. So we have gone through a tremendous amount of detail in a very short period of time. I'm sorry if I talk too fast, but as you can tell, this is a lot of information. So thanks again for everyone coming along. We're going to open up the floor to questions. And like I said in the beginning, if you want to set up a time to chat, there's my contact information. My office is in Front Street, right in Harrisburg, north of the governor's mansion. So I'm right around the corner. I'll be more than happy to sit down and talk to you. There are no strings attached. There are no expectations. Let's just have a conversation and help you get in the right direction.